Well, that whipsaw effect gun owners are feeling right now after a 7th Circuit Court of Appeals judge issued a stay on the Southern District judge's preliminary injunction against Illinois' gun and magazine ban. Good morning. Happy Friday. Springfield's Morning News. I'm Greg Bishop on 92.7 WMAY. Springfield's News and Talk. Love to get your thoughts on all of this. 217-629-7970. That's the phone number where you can sound off and have your voice heard about the latest in the litigation against Illinois' gun ban. So yesterday we were talking about how last week a federal judge out of the Southern District of Illinois issued a preliminary injunction. In the case, you had 4 plaintiffs groups sue the states over the state's gun and magazine ban, and those cases were consolidated, and the federal judge heard that case April 12th, and then weeks later, last week, he issued that preliminary injunction putting a hold on the state enforcing the law. And that led to gun stores across the state seeing a flood of customers coming in to purchase the items that they wanted to purchase and haven't been able to purchase since Governor J.B. Pritzker enacted the ban on January 10th. So since then, a lot of lawsuits in state courts and federal courts, and the latest being in the federal court, where you've got the 7th Circuit Court of Appeals taking up the state's motion for a stay, which essentially reverses Judge Stephen McGlynn's preliminary injunction that halted the law for less than a week. So there were 6 days there from last Friday to late Thursday where gun stores were selling semi-automatic firearms and certain magazine capacities to customers who were going to those stores. And a lot of the gun stores reporting that, they had to tell people we're not taking any more customers today. We've got too many to take care of right now. A lot of stores getting new inventory in, but all of that coming to a halt after the preliminary injunction was reversed by the 7th Circuit Court of Appeals. And just to look at some of the thinking here that the judge. If you look at the docket for the appeals court and the order that was issued, it's a 1-page order, and it looks a little bit like this. And if you look at it, it says the following is before the court: state defendant's emergency motion to stay the district court's preliminary injunction order pending appeal, filed May 2nd. That was, of course, after the states had asked Stephen McGlynn to reverse his stay pending appeal. McGlynn gave a timeline for people to file briefs, and then you had the states supersede that and go to the 7th Circuit Court of Appeals, as is their right, to ask the appeals court to put a stay on McGlynn's order. So that's why the 7th Circuit Court of Appeals took that up, is it was at the state's request. But looking back at the 1-page order from the judge in the 7th Circuit Court of Appeals, Frank Easterbrook, he said that the motion's granted. Further court order possible, but any response to the motion for a stay must be received by May 9th. That's the day after McGlynn gave the plaintiffs in the Southern District time to respond to the state's motion for a stay. And it also goes on to say, the 7th Circuit Court of Appeals, any response should discuss the bearing of Friedman v. Highland Park, a case from 2015, and a 7th Circuit case from 2015. And also Wilson v. Cook County, a 7th Circuit case from 2019, in addition to any other matters that appellees deem pertinent. So a 1-page order from Frank Easterbrook. A lot of people critical of this, saying that the judge is referring to cases from several years ago that are before the New York State Rifle and Pistol Association versus Bruin case that the U.S. Supreme Court ordered that was put back down to lower courts. Essentially now that precedent is being used to say you cannot have bans of commonly owned firearms, and you must use text and tradition when analyzing gun laws and whether or not they're constitutional. So a lot of criticism of this judge in pointing to these various orders that were older than what you saw from the previous court precedent. So where this goes from here, we shall see. But obviously, the headline is that you've got a federal appeals court reversing that injunction on Illinois' gun and magazine ban. Now, the Illinois State Rifle Association, they put out a statement saying the court, for whatever reason, has chosen to issue an emergency stay while the state's actual motion for a stay is being briefed and considered. And again, that's in the Southern District. We're frustrated by this development, State Rifle Association says, even if only temporary, as all legal firearm owners in our state, and they're all frustrated. Fortunately, the briefing is being completed on an expedited basis. We hope that once the court considers our position on the injunction and the law's unconstitutionality, the stay will be denied. The Illinois State Rifle Association will not stop fighting for our Second Amendment rights. So, again, you've got the reaction pouring in, even from Governor J.B. Pritzker, who posted on Twitter. He says that, as I've said, since the passage of this law, the Protect Illinois Communities Act, this is a constitutional piece of legislation that was carefully crafted by members of the General Assembly and advocates to keep Illinois communities safe. Although the legal battle will continue, this ruling by the court is a step in the right direction that allows us, the state, to keep dangerous weapons off the street. I'm thankful that through this ruling, Illinois law enforcement can continue to enforce the ban on the sale of high-capacity magazines and assault weapons while this case makes its way through the court. So Governor J.B. Pritzker reacting, thankful for the Seventh Circuit Court of Appeals stay. You also have the Attorney General, Kwame Raoul, issuing a statement on Twitter saying that we're pleased with the court's decision to stay the preliminary injunction issued by the Southern District. The decision means that the Protect Illinois Communities Act remains in effect throughout Illinois. We continue to be committed to defending the law's constitutionality in courts. So those are two of the major players behind this, but you also have the state's representative who sponsored the Protect Illinois Communities Act, State Representative Bob Morgan. He put out a statement saying that today's ruling in the Seventh Circuit once again ensures the Protect Illinois Communities Act can continue to save lives in Illinois. We know the fight isn't over. The gun lobby will continue to try and block any common sense efforts to keep assault weapons off our streets, but we aren't backing down, and this ruling only strengthens our resolve and confidence. Assault weapons are killing machines that have caused carnage in too many of our communities, and this law is a powerful step forward to the path of ending the devastation of gun violence in Illinois. So you see, of course, the reaction back and forth of the preliminary injunction being reversed. It wasn't an order. And I think one thing that people need to fully understand here is these are all preliminary steps. They really have not taken up in the federal courts for the Southern District the merits of the challenge of the state's gun ban on the grounds of the Second Amendment. While other courts in the Northern District have taken up, for instance, the Naperville case or the Cook County case, they've also issued denials of preliminary injunctions, and those are in the Seventh Circuit, and even the Naperville case being considered by Supreme Court Justice Amy Coney Barrett. We'll see where that goes, but all of these steps are preliminary, and the Southern District still has to hear all of the merits of the case and determine the constitutionality of it. The preliminary injunction really was just a first step while they continue to consider the merits of the case, and the preliminary injunction really is a statement by the judge saying that the judge believes that the plaintiffs are going to succeed in challenging the law based on the merits. Again, this is the federal case, nothing to do with the state cases. Something else to note here is that the state cases where you've got the Macon County case from State Representative Dan Calkins, that's going to be heard by the Illinois Supreme Court May 16th. And we'll see where that goes. The state level cases challenging the law's constitutionality on equal protections grounds because the law carves out rights for some but not for others. So that's one of the arguments. Then you also have the cases that Tom DeVore brought. And those are, again, in the state court. And you've got thousands of named plaintiffs in gun stores in those cases. In Calkins' case, also in divorce cases, thousands of individuals who have a temporary restraining order in place protecting them from the law being enforced against them. So while the statewide preliminary injunction that was issued by Stephen McGlynn has been reversed, you've got the state cases Tom DeVore brought where the preliminary temporary restraining orders are still in place. So those named plaintiffs who paid DeVore, who were part of Calkins' case, they're safe from enforcement while those lower cases continue in the state courts. So interesting back and forth here, and where all this goes is it's going to be fascinating, and we'll be watching it all and giving you the latest here with Springfield's Morning News on 92.7 WMAY, Springfield's News and Talk.